Good morning, all. We are actually here for the appellate case before us. I am going to actually turn it over to our county staff to moderate, and we will be here to deliberate at the conclusion. So we'll hear instructions at all, but thank you all for being here. Actually, I'd like to start, if we could, with the Pledge of Allegiance to open us formally, so if we can. If you are able to, join us by standing and helping us recite. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, and with that, I'll turn it over to our county staff.
Good morning, members of the Board of Zoning Appeals. Before we begin, I just want to allow for an opportunity to make sure everyone is present that needs to be here. Governor Barnes, is everyone here? Russell, is everyone here for you? Okay. Good morning. This is an administrative appeal hearing before the Board of Zoning Appeals, sitting in a quasi-judicial capacity to hear an appeal of a decision from the Water Department. The procedures for the appeal hearing shall be as follows. Any hearing motions heard and ruled on will come first. If the hearing is to proceed, each side has an opening statement limited to 3 minutes. Each side has 20 minutes to present their case, inclusive of cross-examination. With the appellant presenting first, each witness shall be subject to cross-examination by the opposing party. Each side may present a summation limited to 3 minutes. The members of the reviewing body may question each witness and shall not count against each party's allotted time. The appellant may reserve time at the remaining time for rebuttal, and upon request, the reviewing body, the board, may in its discretion allow for additional time for each side, which that may end up being a pre-hearing motion or agreement. The rules of evidence set forth in the Georgia Civil Procedures Act shall not apply to the hearings described in this section. Upon any objection by either party, the hearing officer shall rule on the admissibility, and evidence shall be admitted if necessary to serve substantial justice. The legal standard of review to be applied by the reviewing body, the Board of Zoning Appeals, shall be an abuse of discretion. At this time, we're starting at 9 o'clock. The goal is to go until we conclude, till a decision is rendered by the board, or a decision by the board to come back at a later date to render the decision. The Board of Zoning Appeals, as a variance board, convenes at 1:30. If additional time is needed for this hearing, we will reconvene after the conclusion of the Board of Zoning Appeals variance hearing, whenever that may be. So we can discuss that when we get closer to noon, if we are still going here in this subject matter appeal hearing. At the conclusion of the hearing, the reviewing body may issue a ruling or may take the case under advisement. In the event the reviewing body takes the case under advisement, The chair will announce the board's intent to render ruling with approximately an X number of days. Does not have to be a certain date and time. The reviewing body may direct the parties to submit with a certain number of days written proposed orders or decisions. The reviewing body may discuss at the next work session. However, the final determination must be announced at the public meeting, which is improperly posted and notice given. Council shall not discuss the case particulars with members during the advisement period. No emails or public statements on this issue that occurred after the date of the hearing should be taken into consideration by the members. Following a decision by the reviewing body, a written decision shall be issued to the appellants and the property owner. Are there any questions before we begin from the Board of Zoning Appeals as to the procedure?
No questions. I just would love to remind everyone if they would turn their cell phones off or silence them so as to not have interference with the broadcast. Thank you.
At this time, I will turn it over to the parties, to their counsel. You'll each have 3 minutes for an opening statement if you desire to make one.
First, I have a constitutional challenge to file with the clerk.
Okay.
And I do have objections to the procedure. One, is it all right if I sit down?
Yes. Can we get a microphone?
Number one is a constitutional challenge that must be made at the first hearing, and it's filed. And is filed with the clerk or whoever acts as clerk. We have a court reporter here, and I propose that she be the keeper of all exhibits, if that's agreeable with that.
Typically, the clerk, who is from the county clerk's office, receives all the exhibits for the record, but we certainly, if they want to be shared with the court reporter.
That's fine. That's
Yes.
fine. Okay. Who's the clerk? Secondly, a limitation on time of 3 minutes and 20 minutes is unreasonable under the, for a judicial hearing, quasi-judicial hearing, which this is, and violates due process if you insist on preserving that. Secondly, the hearing is subject to the rules of evidence. Your ordinance has been overruled by the Georgia General Assembly and OCGA 24-1-2 that says that the rules of evidence apply in administrative hearings. The rules of evidence as applied in the trial of non-jury civil actions shall be followed, subject to special statutory rules or agency rules authorized by law. And there has been none authorized by the General Assembly. So the rules of evidence apply. Thirdly, the abuse of discretion standard only applies to factual determinations and not to legal determinations, and the issue before you is a legal determination in the interpretation of an ordinance. You cannot have an abuse of discretion standard for a legal determination. The law or ordinances are law and cannot be violated by any type of rule. Fourthly, as your distinguished counsel has pointed out, you sit in a quasi-judicial capacity. And that means, and I will introduce in appropriate time cases, that means that if you have received any information regarding this matter or conversation, you are disqualified because you're not a fair and impartial person to hear a quasi-judicial matter. It is like going to a judge and says, "Judge, I got a case before you. Let me talk to you about it." This ex parte communication is prohibited, and I call upon anyone, and you may not have had any, of course, but if you received any information outside what will be presented here today, then I call upon you to recuse. Is there any person that's received any information? All right. Let the record state that no one has so stated. This is I question why we're here, but this seems like straining at a gnat. You will see a plat of this property, which has been approved by this is R20 subdivision, OSC R20, which means Open Space Conservation Subdivision. It's our old farm on Brown Road in Powder Springs. When I bought it and moved cows there 25 or 30 years ago, I didn't think that Cobb County's growth would extend that far. Now I have subdivisions on all sides of me. I can't keep cows there anymore because they tear down my, whoever, kids or whatever, tear down my gates. I had one gate torn down 5 times. And they vandalized my barn. And so I moved the farm to Polk County. Hopefully, hopefully the development will not force me out of there. And we've farmed here in this county for over 100 years. And in fact, the tax assessors told us we were the last, us and the Bentleys were the last 2 operating farms in Cobb County. Now, so the property is zoned. This is not about zoning. The property has, the reason it was zoned OSC was it has large parts of open space that join Sweetwater Creek, which to my knowledge is the largest basin in Cobb County. It feeds into the Chattahoochee Basin. There's 192 acres, and there's only 114 houses that are going to be constructed on 192 acres. Cobb County has a sewer line, a main sewer line that runs on and in Sweetwater Creek, which forms the boundary of this property. Because of where the manhole is placed on the other side of the creek, and the property line goes to the center of the creek. Because of where it is located, it was necessary for a private lift station to be put in. Private lift stations, I will show you, are all over the county, including Cobb County, which uses lift stations. So it's not anything new, but Cobb County has regulations under it. And those regulations are found in, and I'll submit this to you so that you won't have to read it. It's submitted in section 122-126 of the regulations of Cobb County. And there's public lift stations, which not involved here. This is a private. Public lift stations under the ordinance are supposed to be done away with, and they haven't, of course. And private lift stations are used by all of the adjoining counties in Cobb County. And there's really no dispute except one issue, which is a legal issue in my view, that this that every requirement is met in this lift station. The first requirement is that force mains with private lift stations are not allowed in the public right-of-way. Well, this one is not. It's located on a permanent easement. Cobb County uses easements all the time, and I'll talk about easements in just a minute. Private lift stations serving more than one residential or non-residential property may be considered subject to the following conditions. There must be a single viable entity responsible for the ongoing cost for maintenance, and that'll be the Homeowners Association. It's Appaloosa Homeowners Association. That's been agreeable to the county. Yes.
Governor Barnes, before you continue, let me inquire just to make sure that this is your opening statement and that you are wanting more time because you have gone over time. And whatever time you go over will be allotted and afforded to.
Oh, sure.
Okay.
I admit that. I mean,
Thank you very
my
much.
distinguished counsel is entitled to.
And we have no objection to additional time.
Thank you. So whatever time you take will be the time afforded back to.
Oh, sure, sure.
Thank you.
I agree with that. I just talk slow. It's hard for me to say anything in 3 minutes. I will tell you much of my name. The second requirement is the station pumps to a manhole located on one of the properties served from which sewage can flow by gravity to public sewer. This is the legal issue right here. There's a permanent perpetual easement that is part of this property, and it goes to a manhole. And we say, that's it. And also, and I will cite the appropriate cases, if there's a doubt as to, and this is the reason I objected respectfully, to saying, well, it's an abuse of discretion, not as a matter of law. If the ordinance says something, the ordinance does something. If it is subject to two interpretations, the law says that the owner gets the benefit of the doubt. And the reason is Georgia has a provision in its Constitution. In fact, in the Constitutional Convention of 1982, it was reaffirmed and strengthened that says the right of property is paramount in the state. Where the Constitution of the United States does not protect property explicitly, it protects property from being taken. That's not true in the Constitution of the state of Georgia. So if there is a doubt as to the, or if it's ambiguous in any way, the landowner wins as a matter of law, not a matter of discretion, a matter of law. And let's examine that. The station pumps to a manhole located on one of the properties. An easement, as I will cite to you, is a right in property that excludes all others from interfering with it and being involved in it. If that were not true, there would not be a safe sewer or water easement in Cobb County. When Cobb County gets a sewer or water easement, they can keep everybody else off of the property, and they can use the property as they see fit. So there are two parcels here. One, which is the main parcel, 192 acres, and the other is a permanent easement giving access to the manhole, which is right across the street. I mean, right across the creek. And so when it says the action pumps to a manhole located on one of the properties, it does pump to one of the properties, served from which sewage can flow by gravity to a public sewer. No question that exists here. In fact, right across the creek is a full subdivision served by Cobb County Sewer. Now, the pump station pumps to a manhole from which sewage can flow by gravity to a public sewer. Now, Cobb County, I'll give you a little preview, and they sent you their position yesterday, which I've objected to I mean, I've objected to some of the statements they have in it, is they said, well, it has to, on the property where the manhole is covered, it has to be served by the pumping station. There is no such requirement. And in fact, the property on which the manhole is covered, is located, goes to the same outfall line from this manhole. It all goes to the same line. Now, why we're up here fighting that we should have septic tanks rather than sewer is beyond me. It's always been the other way. But because this is so close to as you will hear some testimony, because this is so close to Sweetwater Creek, the effluent could come out from septic tanks and pollute the river, pollute the creek. It's a river. It's a good size. I don't know how many of you are familiar with it. But the other thing is that you don't have, when we've had rainy weather like we've had the last few days, septic tanks fill up real quick. And the reason they fill up real quick is because the water from the ground goes into the septic tank and it leaches out. That's not true in the sewer. The sewer, excuse me, the sewer is encapsulated. It's within a pipe, and so you don't have excess water or leaching into it. And then the third requirement is no feasible means or serving the properties without the use of a lift station is available. The county does not dispute there is no feasible way except with a lift station to serve this property. Because the manhole is on the side of a bank, you would have to elevate, and then that can be economically infeasible, into the air a line that would flow strictly by gravity. And they don't dispute this. The next is maintenance agreements are in place with a qualified firm to provide for no less than annual inspection and maintenance of the lift station and a report provided to the county. No problem here. That's been met. Applewood Services, Inc., which is a standard company that performs annual inspections and maintenance, has agreed to be available for it. The next provision is that provisions are in place, perhaps through a bond or escrow amount, to ensure that future station costs are provided for in the event that the responsible entity, that is a homeowner association, is unable to meet its obligations. We've agreed, and the county's accepted, that we'll deposit $50,000 into an escrow account controlled by the county. So if there's any problem in the future that the homeowner association doesn't maintain the lift station, they will. That there'll be money there to do it. And in fact, we will introduce to you, the only thing in a lift station is the pumps. There's a main pump and a backup pump. And in the pump, there are brushes that move the water, fluid, or whatever. We had and they generally are warranted from 10 to 20 years. We have a company, the main company, that provides to the county and for everybody else called Xylem. They said that they could replace the brushes, the interior of the pump, for about $17,000. So they're going to be new. They'll be good 10, 20 years. The homeowner association there is, if they need to, of course, they'll have homeowners dues that will approve it. And then if they were to fail, there'd be $50,000 with interest for 10 to 20 years to replace. The county has not objected to that. Says that's reasonable. Then the next thing is that no public wastewater facilities are tributary to the private lift station. In other words, one property, that is, one subdivision. There's nothing tributary to here, and that's not disputed. Then that you will have appropriate notifications provided to the property owner when they buy it that there's a private lift station. This is the covenant that we've agreed on that be put in. Your property is served by a private lift station. This will be in every deed. Your property is served by a private lift station, the homeowners association. The homeowners association is responsible for the maintenance and replacement, if necessary, of the lift station. There is no guarantee Cobb County will provide any assistance for the private lift station maintenance or replacement. In fact, and that language has been deemed appropriate and okay. In fact, an open records request, we could never find a lift station, private lift station, that the county had to take over. And then it says you'll go to the state, and the Environmental Protection Division of the Georgia Department of Natural Resources shall approve the on-site private sewer system. We went to the state of Georgia, applied to the Environmental Protection Division. They said, why are you even thinking about putting septic tanks on this property? I said, don't ask me, ask Cobb County. And they approved a private lift station for this property. So, what do we have? We have a situation, and you know, I've been in politics my whole life. I've gone straight, as I tell people. But there's been a little political interference. You know, Roy Barnes sues the county all the time.
Into the mic, if you will, so that we can
I'm
hear you a
sorry.
little bit better. Thank
Okay,
you.
can you hear me now? Hear me now?
Yes.
Okay. He sues the county. I do. I represented the DA recently against the county in a matter that was resolved in favor of the district attorney on a pension matter. You know, let's make it a little hard. Tough. That's the reason we're here. I suggest to you that will be a reasonable inference. So we come back to one language. It says the language that says the pump stations, the station pumps to a manhole located on one of the properties. Is the manhole located on one of the properties? That is the easement property or that it adjoins? Yes. From which one of the properties served, and the property served is not only where the manhole is, but also one of the properties served is this subdivision, 114 houses on 192 acres with open space. I mean, there's almost 2/3 of this property that's going to be open space. And so the language says what it says. Now, my distinguished brother, and let me tell you, you have a fine lawyer here, Russell Britt. Russell's a great lawyer, a great friend of mine, and is very competent. He contorts this language to say the station pumps to a manhole located on one of the properties served. Well, he says it's not served. It is served, but the main property is served. And so, though you will hear some testimony today, the language says what the language says. Now, let me say one last thing, and then I will hush and allow my distinguished brother to speak for as long as he wants. Governments have to deal with citizens. in a non-arbitrary, non-capricious manner. They can't just say, this is a rule for you, but we'll wink and nod on another. This is arbitrary and capricious. I use those words because they are words of art and cases that says when a government acts arbitrarily or capriciously and the regulation further must have a connection to the public safety or welfare of the people. And if they don't have that, the whole thing is invalid. And that makes sense because Georgia's Constitution says the protection of property is paramount. And if there's a doubt of the way regulations are interpreted, it goes to the landowner. And by the way, even after you do all that, unless there is a valid safety or welfare concern, then you cannot withhold the approval. This has been going on for over 3 years. Over 3 years. Over hooking onto a sewer line rather than allowing septic tanks to flow into Sweetwater Creek. Thank you, that's all. That's my opening statement. I don't know how long that was, but that's it.
So the total time was 20 minutes and 33 seconds.
May I just use the lectern?
Yes, yes.
Brian, can I just raise a point of privilege, Madam Chair? Or it may not be personal privilege, but Madam Chair,
Yes.
just make inquiry. I was on the Planning Commission, I believe, when this matter came before it. And when I say this matter came before it, there was certainly no granular question like this regarding lift stations. But there were certainly, I have just kind of as you said, it's been several years. I have just a vague familiarity with that, with this, and certainly had discussions after that fact with my appointing commissioner about what happened with the zoning case, but certainly have not had any discussions with the Cobb Water folks. The lady here today on behalf of Cobb Water as the representative was our Rotary speaker last month. We did not discuss this case. I just want to make sure that it's appropriate for me to be here, given the fact I was involved in the Planning Commission matter 3 years ago. So I just raised that.
Thank you for raising that. Before you begin, Mr. Johnson, can you weigh in?
I can. I would defer to both the council if they have a very brief opinion before I render my determination of whether or not Mr. Bloin is qualified to sit.
He said, who is your appointee?
He needs a microphone.
Kelly Gambrell, District 1.
And you discussed the zoning. Did you discuss water when that was done?
My recollection is the discussion of water had more to do with fears of flooding than anything regarding use of lift stations. I don't have a specific recollection of that being a critical issue at the Planning Commission.
Do you?
I do recall someone showing up and talking about flooding that had occurred there in the past. I do recall that.
And you realize that all of the construction is outside the 100-year floodplain?
I don't have any recollection of that at this time. I mean, I'll hear the evidence. If I'm left on here, I would hear the evidence today. I don't have any recollection. I don't really have much recollection of what the facts are, but I don't have a basis to dispute what you say.
Well, I like Mr. Bloin, but I think that we're entitled, since this is a quasi-judicial hearing, to someone that has no prior knowledge.
I honestly don't think they're related. And
it sounds like he has no recollection of any issues discussing water or sewer. I mean, obviously, he was talking about the potential flooding issue, which was the issue at hand in the zoning litigation that has since been resolved. And this is separate and distinct from that.
As to Mr. Boyne's question presented of whether or not he thinks there might be a conflict, I do not think a planning commission's turn on looking as to the use and making a recommendation would disqualify you per se as to the question presented here, which pertains to a technical part of a code in question relating to easements and lift stations, if I believe that's what this is going to be about. I don't think recusal is necessary. If this becomes a point of contention later, we can certainly address that through an argument or a brief, present it back to myself or the board, but I don't think recusal is necessary. As Governor Barnes says, that the quasi-judicial board has no prior knowledge, but that doesn't mean there is a complete absence of any understanding or reading the news or anything like that. I don't know that would disqualify you per se. If it gets to a point where you feel uncomfortable, you can certainly bring that to the attention of the hearing officer or the chair as this proceeds.
Due to the fact that, I'm going to raise one more thing at this time, due to the fact that in the recent election in District 1, the recent primary election in District 1, the issue of lift stations around Lake Allatoona was an issue, as between the candidates, I do think it would be more appropriate if I recused myself from this matter, given the fact that council and the applicant have raised a concern. I just think it would be safer for the county to proceed without me.
Well, that would be at your discretion at this point. You could not be prevented from recusing yourself if that's the case. Absent they're losing a quorum, but I believe if that's your discretionary field, you're certainly welcome to recuse yourself.
Yeah.
But remind yourself that you need to be back here for 1:30 for the.
Thank you. I'll stick around. Thank you. I'll stick around. I'm recusing myself, and I appreciate that, and I just think that avoids any potential appellate issue in that regard, as I have not otherwise substantively participated or asked a single question otherwise here today. Thank you.
Thank you, Commissioner Boulogne. We'll give you a few moments to exit before the other side begins. And we do have lunch scheduled for you, too.
Mr. Britt, you have 20 minutes and 33 seconds.
That is a long time that I will not need. Good morning, Madam Chair, members of the board. I'm Russell Britt, and I represent the Cobb County Water System. Now, I can be brief because we already submitted the water system's position statement that y'all should have received, and so I can get right to the point. Governor Barnes did an excellent job of providing some background context, but the question before you is simple, and it's just one question, which is, did the water system reasonably apply the county code in determining that this sewer proposal does not comply with the code? And the answer to that question is yes. Now, from the outset, the water system has been clear and consistent. The wastewater management plan for this area of the county does not support public sewer, and the reason for that is the topography. And so the water system has been very consistent with the developer of this project in explaining that septic is otherwise a viable option. But despite that, the developer pursued a workaround through a private lift station. Now, the county code, as Governor Barnes pointed out, does provide for private lift stations. However, it's only provided or allowed if you meet very strict conditions. And we agree that every condition has been met except one, and there's one that we disagree on. The code requires that a lift station pump to a manhole located on property served, those two words together, property served by the lift station, from which sewage can then flow by gravity to public sewer. The other side is trying to suggest that this language is ambiguous, and therefore you should construe it in the favor of the property owner. However, the water system disagrees, because at the end of the day, this language is plain and unambiguous. In our position statement, we cited the case law explaining how you get to that point, but in layperson's terms, I don't think anybody could dispute the fact that it requires the lift station to go to a manhole on property served by the lift station. And this requirement is straightforward. And I don't think the other side will dispute the fact that at the end of the day, it doesn't go to a manhole on property that is served by the system. They can't dispute that. There's no genuine dispute. Now, why do we have that? There will be testimony that you hear today for the reasons that go to the health, safety, and general welfare of the county, which is when you've got a private system that's more complex than gravity flow, that has the opportunity to malfunction and create a hazard, the county's goal is to only impact the development that's using the private lift station that then is connected directly to public sewer. Otherwise, you have a middleman, a third party that's in between. If you accepted the easement argument, which we dispute, then you've got a situation where you could have an environmental hazard that expands beyond the easement onto that adjacent property. So that is a main reason why the purpose behind this plain and unambiguous language. It's not arbitrary. It's not capricious. It's plain, unambiguous, and has a goal that promotes the safety and welfare of the general public. So at the conclusion of the evidence, I'll ask y'all to do the same thing that the water system did, which is to apply the ordinance as written. And when you do, the result's clear. The proposal does not comply, and the decision of the water system should be confirmed. Thank you.
Thank you. You still have 16 minutes on the clock.
I will yield my time.
All right, time is yielded. Mr. Johnson?
So at this time of the hearing, the parties are now able to present their evidence and bring forth their witnesses. I understand from Governor Barnes that he would like more time. Now, there's two ways we can handle that. We can predetermine how much time is offered by a specific amount, or we can see how long Governor Barnes goes, and then at the same time, I would try to encourage the council to find somewhere in the middle perhaps so there is some sort of time that we know to set. So you think there needs to be more time to present your so 20 minutes is allotted per the rules of procedure. How much time do you think you need? 30 minutes, an hour?
It depends on whether the witnesses answer the questions. So I'd say at least an hour.
Okay. Russell, is an hour?
We have no objection. We disagree that there's any violation of due process. We'll allow him as much time as he needs.
So, members, at this time, we will set an hour for each side to present their evidence and their case and call their questions. I would advise the board to, at the end of the hour, if they choose to take a break, that might be a good time to do it, or at the conclusion of all the evidence and the presentations. But that's your discretion, sitting in your capacity. So that I will set it for an hour, and if we get to that point, if the board needs to take a break at that time, they certainly can.
I'd actually like to offer a break prior. Do we want to take a break prior to
That is fine.
the hour, and then lock in? I'll leave that to the members to decide.
I think after 1 hour break and then start.
Okay, so we'll proceed, and then we'll take a break after an hour.
Give me 1 second to set the clock, and I will. Proceed.
We call Alicia Giddens for the purpose of cross-examination.
Where do y'all usually?
So the witnesses can stand at the podium up here that way, speaking to the microphone so that everything is recorded. And Governor Barnes reminding you to speak into the microphone so your questions are heard clearly, both by the witness and by the members of the Board of Zoning Appeals.
It'll hook me up so I don't have to worry about that. You ready?
Please proceed.
Ms. Giddens, would you raise your right hand, please? Do you swear the testimony you shall give in the cause now pending shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Ms. Giddens, state to us your position.
The water system director,
All right. And you have been water system director for how long?
since February 2nd, 2026.
Okay, pull that a little bit closer. There you go. And your predecessor was Judy Jones, was she not?
Yes.
All right. Now, hand me the big chart, yes. Lift stations are used, private lift stations and public lift stations are used throughout Cobb County, are they not?
Yes.
Ma'am?
Yes.
And in fact, subject to an open records request, and Your Honor, this is exhibit number 12, we'll give my distinguished brother a copy, and then we will give appropriate copies to the board. Give Russell a copy, and give Ms. Giddens a copy. And excuse me for not standing up. I had a little illness, was in the hospital last week, and I'm still a little woozy. Pursuant to an open records request, this was provided, and this lists the private and public lift stations in Cobb County, does it not?
It appears so.
Okay. Do you have any information to the contrary as you stand here today?
Without, this is the first time I'm seeing this list, so
I'm sorry, I didn't mean to cut you off now.
without having more time to review it, it
Yes,
appears to be a list of the lift stations.
Yes, ma'am. And private lift stations, it looks like to me there's, it starts about 20 and goes through the rest of the page and then on to the next page, correct?
Yes.
Governor, may I pause for a second?
Yes.
The Board of Zoning Appeals would like to see a copy of what
Sure,
you're all looking
and
at.
we have copies.
So whatever y'all are reviewing and discussing concurrently, they could be looking at it
That's
as well.
fine. We will.
Yes, and I have stopped the clock just for this issue.
That's all right. I'll probably go over it. This is Exhibit 12, so give a copy to each member of the board.
And while he's doing that, if I may, I'd like to object on relevancy grounds. I'm not sure why this is relevant to the issue at hand before the BZA, which is the sole issue that the both parties agree on, is whether it complies with section 122-126.
We'll look it up. It goes to motive, and I have our own cross. It appears to me, for example, Mars Hill Village, the whole subdivision is on a private lift station. Does that not appear? Or a good many of them?
It appears so, yes.
Okay. And Midway Presbyterian Church, that's out there on Dallas Highway, is it not?
I am not familiar with that location, but
At Midway Road and Dallas Highway?
yes, I would like to clarify though for the record that prior to becoming director, that I was not involved in the approvals of these lift stations, so I do have limited knowledge of each one of them.
Yes, ma'am, I understand. Cobb County has a fire station at Midway Road and Dallas Highway, does it not?
Governor, before we proceed, I want to weigh in on the objection
Okay.
that Mr. Britt has
All right.
offered. I'm going to let the evidence admissible at this point, but remind that the Board of Zoning Appeals, when, in your discretion, when y'all are reviewing all the facts and everything entered, you take into your discretion of what applies to the question and the decision being appealed, and you take the net determination when you make your decision as to the appeal. But at this time, I'll let that proceed
And-
just for this moment.
And this is fairly short. They have a fire station there.
I assume so. I am not familiar with that fire station.
And there's a veterans center there, is there not?
I am familiar with the Veterans Station.
And both of them are on a private lift station that is not served by the property where the manhole is located.
I do not have any knowledge of that.
Yes, ma'am. Well, it says Midway Presbyterian Church is where the lift station is, and that's across Dallas Highway on the south side, is it not?
Sir, I do not know.
All right. Now, do you agree that all of the requirements have been met by the applicant in this case, except for the one that has been stated here?
That is correct.
All right. Now, I want to ask you, do you have a copy of the ordinance?
I do not have it with me.
Would you
Do
submit number 2, and we'll submit this to you at the appropriate time with the break. Give to the Board of Commissioners and my distinguished counsel to hear the copy of the ordinance, and to the witness.
Thank you.
Would you look at, this is section 122-126, correct?
Yes,
And you're familiar with this code section?
I am.
The ordinance. And private lift stations are listed on the front page, the first page there, correct?
That is correct.
And the second sentence of number 1, that is B1, says, the department director may grant a variance to pump across one adjacent property for a limited distance, provided it does not pose a public health risk. Did I read that correctly?
Where are you seeing that?
1, paragraph B1, and the last sentence, and it's italicized in red.
The code that applies to this development is under number 4.
Yes, ma'am, but that doesn't, what does the title say?
Private lift stations.
And number 1 says,
But we are under number 4, which says
Well-
private lift stations serving more than one residence.
let me object. The question needs to be answered by the witness, not explaining her position. That's my objection.
I would advise the witness to answer the question, but I do believe that her answer is trying to explain her answer.
She can.
Her explanation, yes.
No question about that. And so if you would answer the question, and then you can explain your answer as you see fit. Private lift stations, number one, that's what that says, is it not?
Correct.
And the second sentence says the department director may grant a variance to pump across one adjacent property for a limited distance, provided it does not pose a public health risk. Did I read that correctly?
Yes.
What public health risk would be involved in this case in which a private lift station would pump to a manhole that flows by gravity?
In the case of an overflow?
In case of,
A public health risk would be in case of an overflow.
so Cobb County does not have an overflow?
Of course.
Of course they do. And are you saying that the overflow is greater, risk is greater in an enclosed sewer system than an open septic tank system?
I cannot speak to that. Septic tanks are very safe if they're properly maintained.
Ma'am?
Septic tanks are very safe if properly maintained.
Yes, ma'am, but sewer is preferred, is it not?
Sewer is preferred.
Sewer is preferred. And the reason that sewer is preferred is because the overflow is of less risk, is it not?
Can you say that again?
Okay. Sewer is preferred because it is, number one, the best public health procedure, is it not?
Sewer is preferred because there is, gravity sewer is
Yeah.
preferred because there is less maintenance and less cost.
All right. And sewer is also preferred because the chances of overflow are less than in other systems, correct?
As related to septic tanks,
Yes.
I don't know the statistics on that.
You don't? You don't know that from your experience? How long have you been at Cobb County?
30 years.
And you don't know that from your experience?
I don't know the statistics on overflows versus septic tank failures.
Well, let's just use common sense. Sewer is in an enclosed pipe, correct?
Correct.
And it goes to a countywide system of treatment that minimizes overflows, correct?
Correct.
And a septic tank is not an enclosed system, is it?
The tank
No,
itself?
ma'am, the effluent lines. Are they
Well,
effluent
there's
lines?
the leach fields and the,
Wait.
yeah.
Yes, ma'am. In other words, a septic tank operates by holding the effluent, and then it's dispersed in a field, an effluent field, correct?
Yes.
And that makes it more subject to overflow, does it not? Common sense teaches you that.
I can't answer that.
Can't tell that. Okay. Now, you do admit that the language, the $50,000 is sufficient. Do you dispute that?
That is an amount that was already agreed upon, is that correct?
Yes, ma'am.
Yeah, I don't have any basis to dispute that.
Yes, ma'am. And you have no basis to dispute the covenant that is placed into this is on page 3 for your reference.
The covenant,
Yes.
other than that the adjacent parcel is not subject to those covenants.
The what?
The adjacent parcel that is being proposed for this manhole to be located is not subject to those covenants.
If it were, would that absolve your objections?
No.
I didn't think it would. Now, and you do admit the state of Georgia approved this lift station?
Yes.
If it would help move things along, we would, again, stipulate to the fact that all conditions have been met except subsection B4B.
All right. I understand that. I want to prove my case. And so.
Hearing officer has, I mean, the governor, the appellant can inquire as long as it's relevant, I believe. I mean, for a matter of time, if he wants to use his time that way.
Okay. Have you had any discussions with the state of Georgia EPD regarding this lift station?
I have not personally.
But you've seen the approval.
Yes.
And do you know whether they prefer a closed system or an open system?
I do not.
Do y'all ever talk?
Me and the state?
Yeah.
Yes, but not on this topic.
Well, you knew it was coming. This was coming up. This has been scheduled sometime, had it not?
I did not speak with the state prior to this.
Now, let's look at the language here. First, get out the plat. The plats. We're going to introduce the plats of the property that were submitted to the county. Yeah, undo them and get, what number is it? Well, it's on the board. Yeah. What's the board number? 13 and 14 are two boards that we will introduce, but we have plats that are not on boards so that you can examine this. I think they're both the same, they're just number 2 that way. But give them the plat. I've got a board for you so that you don't have to keep it
Okay.
turned up or anything else. Excuse me. This is number, where's the number on this? Huh?
I think these two are the same.
They are the two the same. They just misnumbered. Tw 12 and 13 are the same, so I'm just going to give you one copy of that if you have any questions. Ms. Giddens, are you familiar with this plat?
Yes.
And this is a copy of what was submitted for approval to the water system, correct?
Yes.
Water and sewer system.
Yes.
Need to speak up just a little bit. Correct?
Yes.
Now, let's read. There are two parcels. Do you agree with me? There are two parcels here. There is this parcel that's laid out as Appaloosa Farms, and then there's an easement parcel, correct?
That is correct.
Now, easements are commonly used by the Cobb water system, water and sewer system, are they not?
Yes.
And they're used as perpetual easements,
That is correct.
and you have the right to control any activity that occurs on that easement?
Yes, it grants you the access and maintenance of the infrastructure in that easement.
And the right to construct and reconstruct, correct?
Yes.
Now, in this language here, it states that it says, okay, the station pumps to a manhole located on one of the properties. This is subsection B, right?
Correct.
And the at the top of the page is the manhole, is it not? Correct?
The private manhole, is that the one we're referring to?
No, ma'am, that's a public manhole. It's one that's operated by Cobb County.
My understanding is that the first manhole is private.
Well, where did you get that? Do you show me that on this plan?
I don't see it labeled. I see the manhole, but I don't see it labeled. On our plans that we received, it showed a private manhole.
Yes, ma'am, but you do agree that there is a manhole, a public manhole on that side of the creek?
There is a public manhole.
Okay. And this house that is located where the easement is located flows to the outflow line of that manhole?
The house on that property connects to the public sewer.
Right there?
That depiction is not the same as what I have seen previously, so I'm not sure.
Well, ma'am, I suggest to you this is what was submitted. And the other issue is that I have is there is no question that the station pumps to a manhole located on one of the properties served. You agree with that?
The code states,
No, ma'am, I'm asking you, I'm read your action directly from the code and ask if you agree as applied to this.
can you state it again, please?
Yes, ma'am. The code says the station pumps to a manhole located on one of the properties. There are two properties, the easement property, this property. So it pumps to on one of the properties, it pumps to a manhole, correct?
You have to read the whole statement.
Well, answer the question and then you may explain. Do you agree that, I'm taking it in order. There are two properties here, you agree with that?
Yes.
And you agree that it that the station pumps to a manhole located on one of the properties?
Yes.
Okay. From which sewage can flow by gravity to a public sewer. Do you dispute that?
State that again.
I'm just reading the code section. From which sewage can flow by gravity to a public sewer. In other words, the lift station pumps to a manhole from which gravity flow will take it away.
That is correct.
That is correct. So, let me ask you just a couple of other questions before I let you down. Are you familiar with the
May I pause for a second, please?
Sure.
The members of the board are asking for some sort of visual that Governor Barnes or somebody can point to so they can follow along.
Okay.
They are having a hard time following along with what they are looking at.
Do you have an easel here?
Is there an easel?
Are you referring to the code section? Because I've got a better copy of the code section.
I'm referring to what they're asking me for the,
We're just requesting that you're discussing where these locations are.
Sure,
We could
sure.
put it up, because we have
Okay.
what you're discussing. This is what the minimum covered areas you're discussing, and this is what
You're going to use your microphone?
Yeah.
So on the mic, so that we can hear clearly, we would love to see some pointing to what you're describing
All right.
visually, so that we can follow along with you.
I'll come.
Thank you.
Can I bring somebody to hold the,
Absolutely.
okay.
Mr.
Can I
Britt, would you like to approach so you can see what he's
Yeah,
pointing to? as well?
Can I ask a question?
Sure.
Is there any possibility to put this on so that we can see it, or is it too large?
Is there a copy that, Governor, that your office has that can be emailed to us really quickly?
I don't, but
Okay.
if you get it down that small, you're not going to be able to see it.
Understood.
In other words, it will be in, you won't be able to see any distance.
And also,
All right,
Governor, you,
hold this up.
a lot
Ms.
of
Giddens,
those,
can you come down right here, over here?
and also, a lot of the areas I think might have.
On your mic?
I have my mic. Never been told I'm too quiet in my life. There's a lot of these lots have numbers, with them, so it would be helpful if the lot has a number, like the number circled, and reference the number circled as we're talking about something, if it's appropriate.
The number of what, I'm sorry, I
On
didn't.
these lots, like right at the top, I think near where the existing public sewer references, it's 1, it's 2, it's 3.
Yes, ma'am. I
Yeah.
got you, okay.
That gives us a point
All
of
right,
reference.
Ms. Giddens, over. I understand what you're talking about. You ready? Can you see? Everybody see?
Very good. Please proceed. Thank you.
All right. Ms. Giddens, this is Sweetwater Creek, is it not?
Yes,
And this whole subdivision up here is served by public sewer, is it not?
I'm not sure about that side, but I know this side is.
I'm talking about on this side of the creek.
Yes,
Okay. And there are two parcels here. One is the larger parcel, correct?
correct.
And then the other is the easement parcel, correct? That connects with the larger parcel.
Right. The easement is here, correct?
Ma'am?
This is the easement, correct?
Oh, I'm sorry. I was pointing to the bridge. This is the easement right here. Can you see?
Yes, we're clear, Governor. Thank you.
All right. And there are two parcels. We've gone over this ad nauseum. One is the easement parcel, and it connects to the larger parcel, correct?
There is an easement that does not make it part of this development, in my opinion.
Well, let's go back to the code if we could. It's not an opinion, it's what the code says. The code says the station, that is the private lift station, pumps to a manhole located on one of the properties served from which sewage can flow by gravity. This property here is one parcel, and this is another parcel, correct?
Yes, but this parcel must be served by this lift station, and it is not.
Well, that's not what it says. It says the station pumps to a manhole located on one of the properties served from which sewage can flow by gravity to the public sewer.
Excuse me. I'm just going to object, ask and answer. She gave you her answer, you just don't like it.
She gave the answer. She said, then she added to it, in my opinion. I want to just take the words of the statute. Do you agree that the station pumps to a manhole? That
Governor
is-
Barnes, allow me to respond to the objection.
Okay.
I'll allow one more question. It does seem like the same question is being repeated, and I do believe the witness is in her best capacity trying to answer it, but answer the question presented,
Yeah, I
and
didn't.
then let's move
yeah.
on.
I understand.
The station pumps to a manhole located on one of the properties served, correct?
Property served by the lift station.
Yes, ma'am.
I know what the code says. I'm very familiar with the
The code
code.
section does not say that, does it? Ma'am?
That is our
That's-
position.
That's your position, but we're bound by the words of the statute, are we not?
This parcel, well,
And it says, and there's no question that one of the parcels served is this parcel, correct?
I'm not clear what you're asking.
It says the station pumps to a manhole located on one of the properties served. There are two parcels and it pumps to one of the properties served, and that is this property and the house property.
The water system has been clear since the beginning of this process that that parcel must be served by the lift station.
Yes, ma'am, and that is found nowhere in this ordinances.
It says property served.
Yes, ma'am, but it says one of the properties served, not the property served that you're trying to make. Is that correct?
I'm
We've
going
been-
to restate my objection, ask
Sure.
the answer.
Okay. Answer the question.
Well, I'd like a ruling on
Okay.
the objection.
I mean, I think the question has been answered. I mean,
Okay.
this is becoming belabored at this point.
Now, while you're still there, hand me the regulation. The Department of Health regulations. It's the last exhibit. No, 15, I'm sorry. Are you familiar with the Cobb Douglas Public Health regulations as it applies to rules and regulations for on-site sewage management systems?
I am somewhat familiar with it, but I have not reviewed this document.
Yes, ma'am. But if somebody had to go put a septic tank in, the Department of Health is the one that has to approve it.
That's correct.
Y'all don't approve it.
Correct.
So I want you to turn over to page 511-3-1-03. Y'all see where we are? 511-3-1-03.
Is there a page number?
Well, it's not paginated, unfortunately. Maybe we need to get the health department to start numbering pages. Everybody got it? You got it, Ms. Giddens?
Good night. Yes, please.
Hello. You with me?
Yes.
And does it say that connection shall be made to a public or community sewage treatment system if such system is available within 200 feet of the property line?
It does say that.
It does say that. Have you scaled to see how far this is from the center of the creek?
I have not.
I've got a scale. You want to scale it?
Without reading the context of this document, I'm not prepared to speak on it.
So let me see if I got this right. Let me ask you to assume that
I'm also going to object. I don't think you've established authenticity of this document. I don't think you've laid the foundation.
Well, the new rule says if it appears on its face to be authentic, it is authentic. And it says Cobb and Douglas Public Health, Cobb County Board of Health. It establishes authenticity of its own. And I've got her on cross-examination.
This being a public document, I'll allow it to proceed. If there is a question of authenticity, we can bring that up at a later date, or the discretion by the board to weigh all the facts presented to it.
Connection shall be made to a public or community sewage treatment plant if such system is available within 200 feet of the property line. Correct?
Again, that is what it states, but without reading the rest of the context, I'm not prepared to speak on that.
You've been there for 30 years, and you know that the Department of Health does not like septic tanks where there's public sewer available, don't you? Do you agree with that?
We have stated public sewer is not available on this parcel.
No, ma'am. It says within 200 feet of the property line. If we go to the middle of the creek where the property line runs and goes up here and it's less than 200 feet, or the Department of Health says, listen, if it's within 200, 250 feet, you got to connect to a public sewer.
If it meets our code.
Ma'am?
If it meets our code.
Well, it doesn't meet your code, because you don't want it connecting to a public sewer, and the Cobb County Public Health Department says, well, you can't put septic tanks there, so it couldn't be developed, could it?
I can't answer that.
Can't answer that. Well, did you ever take that into consideration when y'all go through the bureaucratic process out there? Did you?
I wasn't part of the process when this was initially reviewed.
Yes, ma'am. Now, you can go back, and I'm about done. You know that this matter was completely resolved with the water and sewer department, didn't you?
I'm going to object to the extent that that's inadmissible settlement discussion.
No, sir.
I think that's where he's going.
No settlement discussions. I mean, it was, it's mad.
Well, again, I'm going to maintain that objection and seek a ruling on it.
I don't have information pertaining to what the settlement was, but settlement discussions are not admissible if we are following the rules of evidence in any court proceeding. So if this was a part of the settlement discussion that occurred with the litigation, I will not allow it to move forward.
I'll rephrase the question. Were you present when Judy Jones and had a meet, and Jackie McMorris, the county county manager, had a discussion on whether these requirements had been met?
I was not.
Were you told by, do you have information or knowledge of what went on at such discussions?
I do not.
And were you ever told that one of the commissioners says, we're not going to approve this?
I was not told that.
And have no knowledge?
I know that there was a discussion.
Wait just a minute. You have no knowledge that the requirements were met and that a commissioner said, don't approve it?
I'm going to object to the extent that assumes facts, not evidence. We're obviously here today on an issue of dispute on a condition not being met.
It goes to political interference. It goes to the constitutional issue of whether it's arbitrary and capricious.
I'm going to uphold the objection only because I feel like the questioning has asked if she was present, and she answered a question of whether she was told as to conversations or what to do. If you want to rephrase the question, you're
Yes.
welcome to
Do
do so.
you have any knowledge that has been imparted to you directly or indirectly as to whether it was found that all of the requirements had been met, but that a commissioner said don't approve?
The knowledge that I have is that the water system did not feel that this code section was satisfied. There was a discussion, I have heard that there was a discussion with the county manager and legal present. I was not privy to that conversation, I was not present. I do know that it was discussed with the Board of Commissioners, but that is as much as I know.
Were you there when the Board of Commissioners
No.
discussed it? That's all I have.
I have a few questions on redirect, if that's okay.
Please proceed.
Ms. Giddens, Exhibit 2 that Governor Barnes shared with you, if you could go to that document,
Which
please.
is Exhibit 2.
Is it this one?
Oh, wait. Okay. Got it.
So opposing counsel had a lot of questions for you under B1.
Yes.
Does that provision apply to the application here today?
No,
Why not?
because it is a provision for single property, a private lift station serving a single property.
And in fact, I believe your testimony before is this proposed lift station serves multiple.
Multiple residential properties, yes.
So then that code section doesn't apply. So what code section does apply?
Subsection 4.
Dealing with private
Pri-
lift stations serving more than one residential property?
Yes.
Okay. And I know there was a lot of discussion on subsection B4B, and there was a lot of carving up of the language. But could you just read the full sentence together under subsection B4B?
So it states that the station pumps to a manhole located on one of the properties served from which sewage can flow by gravity to public sewer.
So given that statement, the proposed manhole here on the adjacent property, does the station therefore pump to a manhole located on one of the properties served?
No,
Why not?
because the property that it is being pumped to is directly connected to public sewer, and it is not connected to this private system.
And can you provide, through your experience and expertise, what does it mean for a property to be served by a lift station?
I object to that.
It means that wastewater is
Wait just a
flowing.
minute, Ms.
Oh,
Gibbons.
sorry.
I object to that. Listen, we're limited to the language of this statute, not what her understanding. That is the definition of arbitrary and capricious. The definition depends on who goes out there and asks for it. She is limited to the language of this section and not anything else.
And as the department that is charged with considering and administering this section, she is entitled to take the plain and unambiguous language of it and apply it. And that's what the department's doing.
That's not what she's doing. The question was, what's your understanding of being served was? That's not in here. It's her understanding. That's arbitrary and capricious.
Okay, I'll rephrase the question. Under a plain and unambiguous definition of the term served, how is a property served by a private lift station?
Objection. That's her opinion. If they want to define it, they can define it, but they did not define it. That means it falls to the benefit of the landowner.
That is incorrect because it's plain and unambiguous. Opposing counsel is suggesting that every single word would need to be defined.
No, I don't claim that it would be defined, but he's trying to add a definition that is not in the code section. The purpose of a regulation is that it has to be not subject to the whims of whoever you're talking to at a department. That is what is required here.
I will ask the witness to answer to her best ability. If that includes an interpretation, then certainly, if appealed, that can be challenged.
I'm sorry.
I will let the witness answer the question in the capacity that she feels like she needs to answer it. And if that is something that if anything is appealed, and this is part of the record, that can certainly be addressed in that appeal. But I'll let her answer it in her best capacity, and that has been consistent so far.
All right. Thank you.
Okay, can you state the question?
So what is your understanding of how is a property served by a private lift station?
That the wastewater would flow through that private lift station.
Meaning what? Meaning sewage comes from a house into the
Yes.
lift station?
Yes.
Okay. And let me ask this question another way, given the objection. How does the department apply this provision on property served by the lift station?
I'm unclear what,
Let me try to rephrase it. Given this plain language here in this section, how does we can use this application as an example. How does the department interpret this language and apply it?
we would expect that for it to be served by this lift station, then the wastewater would be flowing through that lift station.
Okay. Thank you. No further questions.
I have a follow-up from that. One of the properties to be served is the subdivision, is it not? One of the two properties to be served is the subdivision, correct?
When we're saying one of the properties served, that is the property that it is flowing to.
Well, where does it say that? Where does it say in this regulation? Let's just take what the language says. It says the station pumps to a manhole located on one of the properties served, and one of the properties served is this subdivision, correct?
That is not how I read it.
That's not how you interpret it. I mean, are you saying the language is ambiguous?
We feel that the language is very clear in stating that it must flow to a property that is served by the lift station.
Well, it does flow to a certain property served by the lift station, does it not?
The adjacent parcel is not served by the lift station.
It's not served by the lift station, but it's served by this public sewer, is it not?
It's
Same
not-
public sewer that this is pumping to.
It's not served by the lift station.
Yes,
That is
ma'am.
our position.
But that is not in here. That is not in here. It says it has to be served by the property to which it flows. Is it? You agree with that?
I've already stated that our position is it doesn't flow to the lift
Yes,
station.
ma'am. And I'm not asking your position. I'm asking you from the plain meaning of the words. That's what it says, does it not? That one of the properties being served
The
Correct.
adjacent parcel is not being served by the lift station.
Ma'am?
The adjacent parcel is not being
No,
served
ma'am,
by the lift
But it's
station.
only one of two parcels. One of the parcels is being served by the lift station, is it
But the
not?
manhole is not located on one of the properties served by the lift station.
The manhole is located on the permanent easement, which is one of the two properties, is
The
it not?
property is still not served by the lift station.
Yes, ma'am. That's all.
Thank you.
Governor, want to give you a time check. We're at 21 minutes.
At 21 minutes?
Yes, sir, left up your time.
That can't be right.
Well, we have paused it for all the objections
Oh, I'm
and
sorry.
and whatnot, so
I was about
I
to
was
say,
trying to preserve that, but
I
if
never
you were,
can finish.
if you are complete, that is your call to make.
Yeah, I'm complete. And I do have some, maybe Ms. Giddens come down.
Y'all are done?
Yes, you may.
I have some documents to introduce, which I would, if I, 10 minutes. Could I have 10 minutes?
Absolutely. If we can take a 10-minute recess?
That is the discretion of the board, that is fine. Thank you.
Absolutely. If we can do that, we can be back
Hold on,
here,
okay.
let's say at 10:45,
Okay, thank you.
11 minutes. Thank you.
Just 1 minute. did, and
All right, welcome back. Thank you, everyone, for the much-needed comfort and convenience break. We will resume.
all right.
Governor Barnes, I believe you have 21 minutes
Yeah.
remaining.
I want to introduce some evidence at this time. We have handed up number one, which is the constitutional challenge. Madam Clerk, you have that. Number two is the ordinance. Do you have that? Okay. Number three is a case that I'll refer to in my closing, and we have a copy of all of this for each of you. Number three is a case that I will refer to during my closing called Riverdale Land Group LLC versus Clayton County. Number four is the Cobb County Water Systems position paper that was filed yesterday. Number five is Bow Fancy Products versus Rayburn County Board of Commissioners, and we'll refer to it in my closing. And number six is the approval letter from the Department of Natural Resources Division of Environmental Protection Division. Number seven is a replacement estimate from Xylem Water Solutions USA, Inc.
Governor Barnes,
Governor,
actually pause.
Is that
while
me?
We're having some
Is
audio issues. Hold on just a second, please.
Is it me?
We don't know yet. I think we're trying to figure that out. I did stop the clock for you, though.
Does that work?
Is it the lapel? Is it the?
Okay, well, I pushed it up. Does that
Okay.
work? Okay. I guess when I move,
Yeah, can you maybe push the clip in so it's on the lapel?
why don't we just put it on the tie? Does that work?
As long as there's no interference, that works. Yes, sir.
All right. Number seven is, exhibit number seven is from Xylem Water Products Solutions USA. It is the, to replace the brushes and innards of a pump that is necessary if it ever becomes necessary. Number eight is the grant of a force main easement that has been referred to here today. Number 10 is a case PHH Investments, Inc. versus Department of Transportation. Number 11 is case Lanier versus Burnett. Number 12 was what? The number 12 and 13 are the big boards. Number 14 is, oh, 14 is due, we'll withdraw. Number 15 is rules and regulations of the Cobb County, of Cobb and Douglas Public Health. And number 16 is OCGA 24-1-2, saying that rules of evidence apply. Now, we will give all of this to the clerk as soon as, and can we distribute now to the members?
Yes, please do. Thank you.
You can go up there. With that, we rest.
Thank you, Governor. So Russell, when you're ready, you have your time to present the defense of the Water Department's decision.
Thank you, Mr. Hearing Officer. At this time, the water system would like to call Ms. Edens in its case in chief for direct. Giddens, I'm sorry.
Thank you for the clarification. And she has already been sworn in, so you can proceed.
Thank you, Ms. Giddens. I'll do my best to cover topics that weren't fully discussed previously. So what is your current position?
Water System Director,
And how long have you been with the county?
almost 31 years.
Almost 39?
31 years.
31. And what roles did you have prior to becoming director?
Previous to director, I was deputy director, and prior to that, I was water protection division manager, environmental compliance division manager, lab superintendent, biologist, and lab technician.
And if you could briefly describe your responsibilities as the Cobb Water System Director.
I oversee all the divisions within our agency, including engineering, and deal mostly with escalated matters that come to the department.
And are you familiar with the county's wastewater management plan?
Yes.
What's the purpose of that plan?
It's just a comprehensive plan that lays out, the plan for sewage throughout the county and the areas that we will serve and won't serve.
Okay, and at this time I'm going to show you a document that we're marking as Exhibit CCWS1, and I will get a copy to opposing counsel.
Okay?
But for the record, this document is the exhibit to the position statement, which the appellant has already submitted to the record.
No objection.
Ms. Giddens, do you recognize this document?
Yes, I do.
Can you describe what this document depicts?
It's a GIS aerial image, and it's showing the area of the county that is not anticipated to be served by sewer.
And why is that?
Can we pause for just one moment? Can we see what you guys are
Oh.
also seeing so that we can follow along, please?
Do y'all have the position statement in front of you that was submitted? If you do, if you go to the last page, it should be Exhibit A.
Thank you.
Also up on
Thank you very much. Please continue.
And as director, why is this area marked as not being served by public sewer?
because the topography, because it sits at a lower elevation, it would require the use of multiple lift stations in this area to pump to the gravity sewer.
Okay. And the proposed subdivision is in fact in that area, correct?
I'm sorry?
The proposed development is in that area?
Yes.
Okay. At this time, I'm going to show you another document that's being marked as Exhibit CCWS2.
Okay. Oh, he's not, never mind, he's not anymore.
Ms. Giddens, do you recognize this document?
Yes, I do.
Can you describe it for us?
It is another GIS aerial. This one is showing in the lower portion the proposed development, and the house at 5135 Browns Crossing Way is the parcel with the easement and the public sewer leaving from that property.
So is this an aerial map that focuses in on the proposed easement area in the manhole?
It does. It shows the manhole, does not show the easement area.
Okay. Can you point out where the proposed manhole is for the board's benefit.
Can you hear me? Okay. So right here is the location of the public manhole.
Point me to a number there, a lot number, if you could.
I'm sorry, Governor?
Point me to a lot number where she is. I can't see it up there.
And I would like to point out that these GIS depictions are, you know, not always perfect. So we believe that manhole is somewhere between, sitting right between those two properties, maybe slightly off.
And by the two properties, you mean 5131 and 5135?
Yes.
Thank you.
All right, thank you. And as director, have you reviewed the written sewer plan comments made between the developer and your staff?
Yes.
What was the water staff's decision on the proposed sewer plan?
It was denial.
Okay. And to back up real quick, what I would like to do is submit our Exhibit 3 for your consideration. And do you recognize this document?
Yes, I do.
Okay, and what is this?
This is a copy of Code Section 122-126.
Okay, because I believe the Exhibit 2 that was previously produced to you for your consideration looks more like a demonstrative. And so what I'd like to introduce this so there's a clean copy in the record.
No objection. Okay. The only difference is I just put spaces in so I can read it. When you get old, you have to.
We can't hear
I
you,
said
Governor.
the only difference in this and Exhibit 2 was I put spaces in so that I could read it. As I get older, I can't see fine print as well as I used to.
And I've got one last. I apologize, we've got too much paper going around here. And I just have one more color copy, so I'll bring it up to the board, but I'll represent to the board that this is the document that was included as an attachment to the notice of appeal. So I assume there'd be no objection for this to be in the record.
No objection.
So, Ms. Giddens, I'll try to be brief on this topic because I know this has been discussed a lot. But if you could go to the ordinance. And if you could read the B4B in total conjunction for us, please.
Okay, so starting at subsection 4, private lift stations serving more than one residential or non-residential properties may be considered subject to the following conditions. I'm going to skip to B now. The station pumps to a manhole located on one of the properties served, from which sewage can flow by gravity to the public sewer system.
And what is the purpose of this subsection?
The purpose is to protect the adjacent parcel owners from being a middleman, so to speak.
Being what, I'm sorry, I missed what you said.
Excuse me?
I didn't hear what you said.
The purpose of this subsection is to protect adjacent parcel owners. So we want to make sure that that adjacent parcel owner has a vested interest, and they are not, in this case, they are not part of the development, so there is no vested interest in this private lift station or private force main.
And if you were to accept the interpretation presented by opposing counsel, would that interest be promoted?
I'm sorry, would that
If you
interest
were
what?
to accept the reading that was presented by opposing counsel, would this purpose be achieved?
No.
Why not?
No, because that property owner the sewer would be going through their property instead of, there's no sewage coming from their property through the lift station. So they're not being served by this lift station.
So in other words, this alternative interpretation would make this provision meaningless.
Right.
So understanding this required condition and the purpose of it, will you please explain why the staff denied the proposed sewer plan? And you can certainly refer to the exhibit I provided you, the comment page.
Yes, our staff has consistently stated that this design still conflicts with Code Section 122-126, subsection 4B, because the lift station pumps to a manhole on an adjacent property that's not part of the development.
And standing here today, you agree with that conclusion?
Yes, I do.
So in sum, based on your review, does the proposed lift station comply with Cobb County Code?
No, it does not.
And is that why the water system determined that the proposal could not be approved?
That is correct.
Thank you. No further questions at this time.
I have a few follow-up just from that. You have lawyers available to you to draft regulations, do you not?
I'm sorry, could you state that again?
You have lawyers, you know, those scoundrels, those lawyers. You have lawyers available to you in drafting regulations, correct?
Our county attorney's office does review our drafts.
Is that a yes or a no?
Yes.
And you will agree with me that a citizen walking in from the street ought to be able to pick up the regulations and know what he may and may not develop his property for.
I would agree.
Okay. And you would agree that if there is a reasonable alternative to your strained view, that the landowner gets the benefit of the doubt.
I do not know that law, so I can't speak to it.
And we've gone over this ad nauseum, but I'm going over. Well, first, have you sought to clarify this regulation at any time in writing, by policy or protocol, or an ordinance?
We did bring forth a ordinance revision, yes,
Did it have this, some change to this in it?
it did.
And what happened to that?
It was not approved at that time.
And when was that?
That was in November.
November of this year, after all this started?
Well, I would object to the extent that inadmissible for any kind of subsequent remedial measure, if that's what
It's not
he's
reme-
implying.
I'm sorry. It's not remedial. Knowledge of the ambiguity and how it doesn't apply is certainly available. And the reason that she brought it forward, because they knew it didn't apply.
I would allow her to answer the question, but I would also advise that actions by the Board of Commissioners as to code should not be admissible as to weighing a decision in this matter.
Did you draft the change?
I did
Or
not.
Did you supervise the draft of the change?
I did not.
And it was turned down by the Board of Commissioners, or was not acted upon?
Correct.
And how was it changed? What was the proposed change?
Without having it in front of me, I'm not sure of all those changes.
Did it clear up the fact that it had to, just what you've been testifying here today?
Again, without seeing it in front of me, I would,
And I'm not going to go over this ad nauseum, but it, just the language it says, right here, it says, the station, that is the private lift station, correct? This is number B.
yes,
The private lift station pumps to a manhole located on one of the properties served, correct?
yes. Well, again, if we read in the full context, I would go all the way back to 4. Private lift station serving more than one residential or non-residential property may be considered if that station pumps to a manhole located on one of the properties served, from which sewage can flow by gravity to public sewer
One of the properties served.
by the lift station,
Ma'am?
by the lift station.
It doesn't say that, does it? It says the station pumps to a manhole located on one of the properties served, not from a lift station, from which sewage can flow by gravity to public sewer.
If you read section B in conjunction with 4, then we believe that that is clear.
Yes, ma'am. The station pumps to a manhole located on one of the properties served. That is true in this case, does it not?
The station pumps to we do not know that
Right.
the parcel is not served by this lift
No,
station.
ma'am, it doesn't say the parcel has to, it says one of the parcels served.
The manhole that manhole, where that manhole is located, is not served by the lift station.
No, ma'am, but the subdivision is served, and it is one of the properties, is it not? You just agreed to that a while ago. It's 2 parcels, the easement property and the subdivision. And one of the properties served is the subdivision. And that pumps to a manhole that is located on one of the properties, correct?
One of the properties within the development is
Where
what,
does it say within the development? It doesn't say that, does it? That's all.
I just have one follow-up.
Please do.
Redirect. Ms. Giddens, and I agree, we've discussed this ad nauseum, I apologize. But as you testified before, if you were to accept that strained interpretation that was just presented to you, would the purpose of this condition be met?
no.
Thank you, no further questions.
But the condition would be met, wouldn't it? Ma'am,
Was that a question? I don't.
that's a question, but the condition would be met. Not your interpretation of it, but literally the words of the ordinance would be met, would it not?
Our position remains clear that the manhole is not located within the development and is not served by the lift station.
No, ma'am, and that's not required under that code, is it?
I'm going to object, ask and answer.
Well, do you ask it again?
Well, I believe that the question has been asked, the answer has been provided, and you have rested your side, and this was reiterated. If you want more time, please ask for
No,
more time.
there's just one other. You say the purpose of this would not be met, and the purpose is to protect the landowner that granted the easement? Is that correct?
Correct.
And so have you gone out there and talked to the landowner? Have you gone out there and said, hey, we're trying to protect your interest here by spending thousands of dollars? Have you gone out there and talked to him?
No.
And in fact, do you know he fully consents and does not understand why y'all are beating around the bush on this?
Our purpose is to
Yes, ma'am.
mitigate any environmental impacts that could occur.
Yes, ma'am, that's all.
No further questions.
Thank you, Ms. Giddens.
And we would just like to tender those exhibits that we identified, which I believe are CCSW 1 through 4.
No objection.
And with that, we rest.
So if both parties have rested all their time for evidence, that provides an opportunity for closing statements. And if you're ready to proceed, we can certainly do so. You have 3 minutes or whatever time you would like to use, Governor Barnes, and then the same amount of time we provide it.
We'll waive the opening and reserve the right to conclude.
And when you're ready to proceed, if there's any statements.
I said we waive the
Yeah.
opening and reserve the right to conclude.
And Mr. Britt, I'll provide the same to you. If you need more than 3 minutes, just proceed, and whatever time you go over, so we'll handle the time.
Thank you. And thank you, Madam Chair and members of the board, for being with us today. This case remains exactly how it was at the beginning, despite all the efforts to try to carve up the plain and unambiguous language. Did the water system reasonably apply the county code in determining that this proposal does not comply? And even after the hearing testimony, the answer to that question is even clearer. It did not comply. Now, you've heard from the director of the water system, and she's confirmed several points. First, the property is located in an area that is not planned for sewer service, and the county's wastewater plan designates it for septic. And that determination has been consistent throughout the process. Second, the evidence shows you exactly how the developer system works. They are proposing a public lift station on the development to then pump through a forced main to an adjacent property that's not in the development and to a manhole on that adjacent property that then connects to gravity flow. However, it's not being served by the lift station. I don't think there'd be any dispute to that. Third, Ms. Giddens explained the controlling requirement of the code. You know, the lift station must pump to a manhole located on property served by the lift station. And she provided you those policy reasons for the health, safety, and general welfare of the people of Cobb County. Again, to the extent that we are going to allow private lift stations, we require clear conditions that have to be met before it can even be considered. And one of those conditions is the condition that we have here today. And as you heard from the evidence, the purpose of that, we want to avoid any potential malfunctioning or environmental hazard bleeding onto additional property that isn't being served by the private lift station in the first place. So if you were to accept the appellant's position, that policy reason goes away. And the provision, the way he is trying to interpret it, becomes meaningless. And you can't do that, especially given the fact that the language is clear and unambiguous. It is so because when you read the sentence as a whole, it requires three things. Three things. The station pumps to a manhole located on one of the properties served. So the station pumps to a manhole located, so it pumps to a manhole located on one of the properties served. Well, you don't even have to go any further than there. The manhole, well, let me stop there and go ahead and read the whole thing. From which sewage can flow by gravity to public sewer. So there are three conditions. It goes to a manhole that's being served, that's also directly flowing to the public sewer. And the basis for that, again, is connecting the private lift station directly to the public sewer. And if you believe the strained interpretation that tries to carve that up and say that's not what it says, even though if we look at it right here, it does say that, then you no longer have any impact or effect of this provision. If it walks like a duck and quacks like a duck, it's a duck. And we've got a duck here. This parcel on this map that they've shown you, where this easement comes up, this lift station, as proposed, pumps to a manhole on this adjacent property that then flows to gravity, right? They have to, because they don't have any property down below that could flow directly. So they've come up with this proposal of creating an easement to then allow them to get to a property to go directly to the public sewer. But that, again, defeats the purpose of this provision. And regardless, even with their proposal, the condition isn't met because this parcel right here, as testified to, isn't being served by the private lift station. There's no house that is discharging sewage into the proposed private lift station from that property. So as a result, you have a intermediate middleman property that's stuck in the middle. And that's simply not what the condition requires and is actually opposite of the condition. And the fact that they have an easement, it doesn't change that fact. Because if you accept their interpretation on the easement, then you could have any developer come to the county and obtain an easement to another property past the private lift station in order to attach to public sewer, and then they're everywhere. Despite the fact that the Board of Commissioners has adopted clear provisions in order to regulate those lift stations. So accepting the developer's interpretation would eliminate this safeguard that's in place, and then any project could route a pipe across adjacent land and claim compliance. But that's not what the code allows. And I know opposing counsel disputes the standard of review, but y'all's appellate procedures provides your standard of review. Abuse of discretion. Under this standard, it's more than enough. But even under the standard that the other side is arguing, the language, as discussed in the position statement that y'all can review, the law's there, it's clear. When the language is plain and unambiguous, you stop. You don't go forward. You don't collect go and collect $200 or pass go and collect $200. You stop. You take the clear language and you proceed. So when you come back to the situation here, the water system applied the clear language, noting these 3 sub-conditions within this condition: flowing to a manhole that connects to gravity flow that's being served by the system. It applied that language. It did so consistently through the comments back and forth to the developer, and it explained its reasoning at every step, that consistent reasoning. So that's not arbitrary. That's not capricious. That's a consistent application of a plain and unambiguous term. So when you return to the central question, does this proposal meet the requirement that a lift station discharge to a manhole on property served by the system that then flows to gravity flow? The answer is no. And for that reason, the decision of the water system should be affirmed. Thank you for your time.
Thank you. Governor Barnes, you have what looks like 9 minutes and 19 seconds.
8 minutes, 19 seconds.
8 minutes and 19 seconds.
I won't take long. I've lived in this county all my life. My family's lived here for well over 125 years. When I have clients that come to me now and say, I want to develop something in Cobb County, I said, don't do it. I said, go anywhere else, but don't do it. You'll never get anything approved, and it just depends on whose politics shows up as to how things are interpreted. There's no dispute on this. Mr. Britt is one of my best friends, and he's representing a client. But as Ms. Giddens admitted over and over and over again, the requirements of this code section have been met. Now, while we're here arguing that you should allow septic tanks rather than sewers is a question of politics. I understand. I've been in politics. You can punish me and everything else. That's the reason I come to y'all. You don't like it. I got access. I got access to you, and I got access to Superior Court. But here's what the code section says. The lift station pumps to a manhole located on one of the properties. Ms. Giddens admitted there were 2 properties. The easement property, which I'm going to cite your cases, you have easement becomes a part of the property. It pumps to one of the properties served. It does not say that where the manhole is located must be served. That's not a strained interpretation. It means exactly what it says. One of the properties being served, and one of the properties being served is this subdivision, from which sewage can flow by gravity, and it does. This policy, well, we're trying to protect the landowner. That's ridiculous. I mean, if the landowner fully consented, he says, I don't understand why they don't let you do this. Here, I'll sign the easement for you. And it's the county's easement. I took the form of the county. It's the county's permanent easement. I'll leave it up to your good judgment. The cases that hold, and number 3 holds that and you can read it. I've highlighted the important part. But it says that y'all act in a decision-making process akin to a judicial act. You're not a member of the zoning appeals today. You're a judge. And the evidence is that you have to apply what you've heard, not what the intent was, what we wish it would be, and we tried to correct it going back to the commissioners. It also says that if there is a doubt, and this is number 5, both fancy products versus Rayburn County, they have some funny names up in those mountains. It says statutes or ordinances which restrict an owner's right to freely use his property for any lawful purpose or in derogation of common laws, they must be strictly construed and never extended beyond the plain and explicit terms. You've heard the reason I didn't call any evidence. She admitted. She admitted it on cross. That, yeah, that's what it says. And that's not what we intend, but that's what it says. Any ambiguities in the language employed in a zoning statute. Zoning statute is defined as anything that governs regulation of property, which this does. Should be resolved in favor of the free use of the property, resolving all ambiguities of the appellants in favor of the appellants, despite a commercial aspect, would constitute an agricultural use. Let me just talk a little bit about the facts in this case. This fellow went up there and he decided in Rayburn County, which is a beautiful place, he decided he was going to have a big gathering where he'd charge people to come in and they could drink and they could do all these stuff. And county commissioners, pretty reasonably, I thought, says you can't do that. That property is owned agricultural. And so the judge enjoined the event and said, well, that's a commercial purpose, not an agricultural purpose. Trying to read in, just like my distinguished brother, tried to read in a definition that does not exist in the ordinance. And the Supreme Court of Georgia says you can't do that. That you got to resolve any ambiguity that exists in his favor, in the favor of the landowner. The other thing that I want to point out, and I'll hush, is that, and this is in 10:11 and 10 and 11, that the easement becomes a part of the property. It's what's called an appurtenant, an easement appurtenant. And if you destroy that, then Cobb County has, they rely on all these easements. Just apply what it says. If one of the parcels is served, well, one of the parcels is served. Not both, not the one where the manhole. They're all trying to read that in. And then this is the last thing I'm going to talk about. I bounce out to you got to put septic tanks on this property. So I looked into that. Board of Health says, are you nuts? You're within 200 feet. And even if you wasn't, we'd make you connect onto it. So where we got? We got the Board of Health saying you can't put in sewer septic tanks. And they don't have anything to do with septic tanks. And they're saying you can't connect to the sewage, the public sewage. something's not right here. That's all I have.
Thank you, Governor. Your time has expired. I believe that concludes the formal portion of this hearing of evidence. And a
If I
closing
may,
statements.
may I hand the exhibits that were tendered to the?
Yes, this is a good time. Anything that needs to be tendered into the record
just
needs to
give her a
be
copy.
provided to the clerk. So, members of this board, at this time, you take upon advisement the evidence that you have heard and you have read and viewed. All discussion needs to be in public and on the record. You may recall witnesses up for questioning. If you choose, there is only one witness. You may ask questions that help you ascertain whether or not there has been an abuse of discretion or something has not been applied correctly. But this is up to you how you want to deliberate. But again, if you speak or if you're discussing it, it needs to be on the record, into the microphone in public. If you need time to just sit there in silence and review the materials, you certainly can do so at your leisure. We are at 11:30. We had planned to go up to noon anyhow. At noon, we will break and then reconvene at 1:30 in your variance capacity, BZA. And then if a decision has not been rendered in the next 27 minutes, we will reconvene a few minutes after the conclusion of the BZA variance hearing for the continuation of this hearing. So if you have any questions, certainly happy to entertain them. But again, any discussion needs to be on the record. You can ask questions of the witness if you choose, but this is up to you how you want to proceed, but everything needs to be out in the public.
I'd love if we would be allowed to take a few minutes to review the documents. But prior to that, if we can clarify what it is that we are to determine so that we're clear as to what our motion needs to be once that determination is made. So if you can clarify what it is that we're supposed to decide, and then if we can take about 5 to 7 minutes to review the documents before us and then begin discussion.
That's fine, and I will pull up the actually appeal statement to provide the question presented.
Please, thank you.
Y'all are just using this time to review the documents, and I'm pulling up the question.
Sounds good. So we'll end our review at 11:41. That'll give us 7 minutes.
You're welcome. Yeah.
We have 1 minute remaining. Do we need more time to review the documents? Okay.
So, Madam Chair, you had asked about what the statement was, and I believe that Governor Barnes is appealing a comment from the Water Department regarding the availability of the infrastructure. I'm looking for that comment exactly right here.
Okay, thank you.
And I believe it's comment F. And please correct me if I'm misstating this from either council.
And I'll certainly work with opposing counsel on an agreement of what actually the question is. But I think the section 7 of the comment page, I believe, discusses it. But concisely, we believe the issue for this board to determine is, or to affirm or deny the water system's determination that the proposed design does not comply with section 122-126 B4B. Is that a fair summary, Governor?
It's fair enough.
Can you
So-
restate that one more time for us, please?
Affirm or deny the water system's determination that the proposed design does not comply with section 122-126 B4B.
Thank you for that clarification. All right, it is now to this board for open discussion based on the information that we have heard. Does anyone want to lead our discussion? Or propose a motion? And we don't all have to speak at the same time. Anyone have any questions of the applicants or our county staff or the witness?
Could I have?
Turn your mic on.
Could I have the representative from Water Lawyer come to speak to the question I have?
The director of the
The
attorney.
director would be good. So I have one question with regards to the manhole that they are proposing to have served from the new property. Does this manhole have the capacity to serve sewage from the house that it currently is serving? Does it have the capacity to then serve all the sewage coming from the lift station across the road to this manhole cover? Does it have the capacity to serve that significant number from one home to however many are going to be built on this new development?
So my understanding is that the sewage would have to flow to a private manhole that's not currently there. And then it would flow to the public manhole by gravity. So the house that's there wouldn't be connected to that system. It's connected to the public manhole.
So explain that again. So the sewage that is going to come across to this is a new manhole that would be put in and then pumped over to the
So it would be pumped to the new manhole.
so it's a new manhole. This is not an existing manhole on this property.
That is my understanding of the plan that I reviewed prior to this meeting, is that there was a transition manhole that would be placed, the sewage would be pumped to that manhole from the new development. It would then flow by gravity to the public system with no connection to that house. The connection from the house is to the public manhole.
So they have their own manhole that goes to the public. This is a new manhole that would be created that would go then to the public.
That is my understanding.
And so in developing that new manhole, that system, would that system coming from the new property to this new manhole, would it have to be designed to be significant in size to be pumped to the main system, to the public system? Is there?
I'm not sure on the sizing. I don't have any information about that, but I'd have to ask staff more questions about that.
Okay. And so that's my
I think what she's
question.
asking, though, there's a capacity.
I mean, I think,
I believe the public forum has closed, and so we're gonna just make sure that the questions that are answered from the panelists, from the board members at this time. Continue.
so yeah, I'm not aware that there's a capacity concern.
So in speaking to that question, the capacity, would you then have to look at what would be coming from this new development to what would be coming to this new manhole as far as capacity before you can make a decision as to what you then would need to then go into the public sewer? Is that a concern with what is developed? I mean,
I think what you're trying to determine is that sewer capacity, is there going to be enough capacity in that sewer? I would have to confirm with staff, but I would think that that's already been evaluated and that this is merely denied based on the fact of that parcel not being served by this lift station.
So it's just being denied that parcel is not being served by this lift station, but not with regards to the potential of the capacity. Is that correct?
Right.
Okay, thank you.
Any other questions for this witness? Thank you so much. Appreciate you. Does anyone else have any questions of staff, of anyone that you've heard thus far? Any discussion that needs to be made? Okay. Does anyone have a motion that they'd like to render? Do we need more time to discuss? Do we want to take moments to deliberate and render a decision for later? Those are the options that we have on the table.
Well, I know that we have to openly deliberate. So as what I proposed, what I asked of the staff, is there any sort of deliberations that anybody has that we would like to discuss that further? Or does it satisfy what has been proposed to us in what they would like to do? I don't know. I just put out a question that we could deliberate on it. Does someone else have a question that they would like to ask the staff or any of the applicant, ask anybody to further develop, like where we're sort of, where there's the questions? I know that there's lots of questions out there. We have lots of material to delve through.
I think that our range of scope is pretty simple. I don't know that we need to look at the proposed development as much as what is being asked of us. And I believe that we're clearly being asked to determine whether or not this particular design proposal complies with county code. And county has presented its side. I hear a lot of provisions that have been made even with the bond for maintenance of systems after construction and development, which is great. it does make me have pause for cause if HOA can't sustain bond moving forward, especially with a 10 to 20 end-of-life type of maintenance type issues with this type of systems. For me, if I'm looking at the county code, what was presented, I'm comfortable upholding the county's decision with the denial of the proposed design.
Well, since you brought up, with regards to the HOA that would be developed and that would have a significant amount of money to hold in case this system does fail, that is a concern of mine because HOAs come and go. HOAs are represented by boards. HOAs are represented by board members that don't have the background necessary. They see a large sum of money that's sitting there. They may have something failing on their property that they would want to use, not understanding that this is a set-aside. HOAs have covenants and restrictions that if they're not updated on a regular basis, they go away. I've had this experience with a few HOAs, so that would be my concern as well, that the system will have to be maintained. It will have to be looked at. It will have to be looked at not 1 year from now, but maybe 15, 20 some odd years from now. So that's a concern of mine as well,
I agree.
that I would uphold what the county code is.
Pull it to you.
That was my concern as well, the stewarding of that money. It's probably the trickiest part.
I believe that the argument regarding B4B does not state that the property be within the development, but it should say that. And as such, I disagree with the Water Department's decision.
Okay. So we're split here a little bit.
Yeah, I did have a concern that the clarity.
I can't hear you.
I'm sorry,
I can't hear you.
I said I did have a concern that we needed to have had another phrase in, I think, B4B to make it very clear that you needed to add that in. I think we add in the lift station reference at this point.
Unfortunately, I don't know that we're able to add words,
but-
and
No, we
we're not
can't.
able
I'm
to
just
add
saying-
verbiage, and so we,
We're not
it's-
allowed to do that. That has to go through the whole.
and I think that that's really what it comes down to, is
Change.
semantics at this point.
Yes.
Ambiguity, how something is interpreted and/or intended from the author. You don't know what the intention is from the author versus the intentionality of the landowner. And I'll add this, I understand that we usually like to press the issue of landowners typically are able to have more of a standing over the county. However, I do also want to note that there are owners that have a varying amount of experience and expertise, and so I don't think that we can also, weigh the two and compare them when we talk about owners, because owners aren't always equally aligned, even in development. Some of them have more experience than others. So, we've said a lot. I don't know that we've come to a decision. Do we want to deliberate further? Do we want to set another date for maybe a possible decision to talk about it in work session? Do we need more time, or do we want to just hash it out a little bit further?
Let's hash it out.
Okay, we have 5 minutes until break. Let's hash out.
The code did not go far enough to delineate about the pump station and this one of the properties. It does not state within the development. It should have stated within the development. And for that reason, I can't support the county water system with their request.
Okay.
But on the other hand, based on what we have in front of us, the county staff followed. It's on and close, can I tell you? Anyway, the county staff did follow the code in making the decision and furthering it on for final decision, and they based it on their best possible knowledge. So it's not like they knowingly went against the request based on the code that they currently have written.
I agree with that line of thinking. I mean, we're looking at what was developed, what was passed by Cobb County Commissioners, what has been our code for, I don't know how long this code has been in effect, but I would say it's been in effect for a long time. So it may not have the verbiage that we need right now to make this work, but this is the verbiage, and this has been consistently held since this has been approved by the Board of Commissioners. And again, I don't know how long ago this code was done, but that would be something that we're looking at what the verbiage says now, not what the verbiage should have added.
Yeah.
So we're not here to say, well, we don't agree with this because we feel this verbiage needs to be added. I'm just looking at what it says right now and what the water department had to work with. When code is made, there's a lot of experts that come in to discuss all the issues. There's a lot of discussion before it gets approved by the commissioners. It gets discussed in front of the public. The process is quite lengthy to go through any code development, code changes. So given that, it doesn't have the correct verbiage that you said that stops this, but it does to me have the enough teeth in it to say that this is not acceptable to do.
I agree with that verbiage. I agree that it doesn't have the verbiage that we need, but I agree that it does have the verbiage that says
To make a decision.
to make a decision to say that we should deny this. So, do we have any further discussion needed? If not, I'll raise a motion, we'll vote and see where we land, and then we'll go from there. Is that okay?
Yes.
That'd be
All
fine.
right. All right, so I'll make a motion that we uphold the denial of the proposed design that does not comply with B4B as per county code. Is there a second?
I second.
There is a second from Commissioner Swanson. Call to question.
So to be clear, you're voting to uphold the county water system.
I am voting to uphold the county water system. Okay, call to question. And it passes 3-1 with a declination from Commissioner Summerhour. All right, and so with that, I believe that concludes this particular hearing. We thank you all for your attention to detail, for coming out, for sharing everything with us, and have a great rest of your afternoon.